Lisa Mackey from Alexander Holborn is going to walk us through the session today. If you have any questions, we do love them as we go through the session. Put them into the Q&A. We already had a really great question, which we'll open up for some discussion as Lisa and I move through the session. If any questions that you don't get, if you don't get answers to, Lisa's email address and my email address are both on the screen. You can send us emails and we'll certainly try and assist you. And if there's something we can't find for you, we'll find you a resource or a person that can help you out for sure. So as we move along, so we'll start today's session. And Lisa, as always, thank you so much. We're looking forward to a fun, great session today. Our sponsor for this session is Curaflow, and they are a plumbing mechanical company who do repiping and pipelining and plumbing repairs in buildings and high rises, and they've been doing it for years and just do a great job of it as they go along. So, private little note on privacy. Just with respect to your questions, they're going to be generic answers because no one would have access to all of your records documents or the evidence that may be associated with a specific question. So they're going to be very general, educational in nature. If you need legal advice on something, we're very happy to refer you to a long list of the lawyers who are available in the industry that can help. We encourage you to share this seminar. It will be loaded to the CHOA's YouTube channel, as well as to the website. So share it with your Strata councils and your friends. And without any more delay, on to you, Lisa.
Thank you very much, Tony. Thanks for joining us, everybody, today for the Lunch and Learn. I'm hoping you're able to take away some useful tips or information that you weren't aware of before. I have my window in behind me. I was hoping it was raining so I could crack a joke about raining cats and dogs, but I'm not able to crack that joke. It was a bad one anyway. Okay, so we're talking about a lot of topics today, and pet bylaws, the Human Rights Code, the laws that govern guide dogs and service dogs. And so all of this starts with laws. And so you all know, as being members of Strata Council or property management, that the Strata Corporation has bylaws. A Strata Corporation must have bylaws. And what do? They're your laws of the land, so to speak. So they provide for the control, management, maintenance, use, and enjoyment of all of the property in your community. So that includes inside your strata lots, the common property, limited common property, common assets of your strata, and it provides for the administration of your strata as well. They are supposed to establish the standards that your community lives. And so you're allowed under the Strata Property Act to pass a variety of different bylaws so long as they don't conflict with some laws, and we'll get there soon. But where can you go as a community? Well, the Strata Property Act specifically says you can put in age restrictions. You're allowed to regulate rentals or prohibit or restrict rentals in your community, residential strata lots, that is. You can govern short-term accommodations, also known as short-term rentals. We try and avoid that phrase, a turn of phrase, short-term rental, because it's a slightly different than a rental bylaw. And if you need to know more about that, CHOA has a lot of material on short-term accommodations. And then there's also the ability to restrict or prohibit pets in your community as well. And that's what this seminar will be addressing today. Another point that I want to raise as well is that bylaws can regulate problems in your community too. They should be unique to your community. So they should be the laws of your land. I see a trend sometimes in communities where they pull bylaws from other strata corporations and just pass it for their community, but it doesn't actually make sense for them or for the population that lives there. So they should reflect your unique needs. And they should regulate the use and enjoyment of all of the property as well. And in a way that your community would like to regulate. So it should reflect you and your area. Rules. You can pass rules. The Strata Property Act allows you to do it. The speeding ticket for breaking a rule is less money than breaking a bylaw, so I'm not really a big fan of rules. You're not allowed to pass a rule that regulates pets or activities within a strata lot. So rules only apply to the use and safety of common property and common assets. They don't regulate what's going on in your home, and that's the territory that a bylaw would regulate. I also don't like rules because there's not a lot of record keeping that I have found that have been quite successful for stratas. So if a strata council does pass a rule during the year, remember there is that time limit on how long it'll be enforceable if it's not ratified at the next annual general meeting or before at a special general meeting. So you want to make sure that you do that ratification process and that you keep a written record of rules. But as I say, I don't like rules. If rules conflict with your bylaws, the bylaw will trump the rule. And as I said, there's a lot less fining opportunity for a rule infraction than a bylaw. So when I'm regulating pets in a community, I certainly would prefer to pass a bylaw than a rule. Okay, so everyone has laws, and where do you start? Well, the Strata Property Act includes a schedule of standard bylaws. So that applies to every single community in the province, unless you've registered different bylaws with the Land Title Office. And so the strata, under the Strata Property Act, can modify these bylaws. They have to be approved at a general meeting, whether it's an annual general meeting or a special general meeting, on proper notice, and we'll get there as well. You're allowed to change, repeal, replace, add the bylaws as you see fit, so long as they comply with the Strata Property Act, and of course some other laws we'll talk about today as well. All right, the resolution is sort of your recipe for changing bylaws, for amending your bylaws, and they're just as critical as how you word your bylaw itself. So when we are doing changes to the bylaws, if we are adding a bylaw to the standard bylaws, if we are removing or amending a bylaw, then we want to make sure that our resolution spells out what we're doing. So it should be specific that this is a bylaw amendment, or that we were previously repealing an existing bylaw. Just because you pass a new bylaw that has the same subject matter doesn't mean that you're actually amending or repealing the previous bylaws. And I've certainly seen a lot of housekeeping problems in communities where more and more bylaw amendments get passed, but the resolutions don't actually speak to replacing or repealing or amending the previous bylaws that are there. And so then what you end up getting is this hodgepodge mess of conflicting bylaws, and nobody wants that. So make sure that when we are passing or entertaining a new bylaw, that our resolutions are clear and that we know exactly what we're doing to any bylaws that were previously registered. In terms of housekeeping, it should also be registered when you register your bylaw. So really important that we have that resolution there. It will dictate how your resolution was passed. So remember, we need that 3/4 vote threshold, and it's a good habit to get into in order to keep your community in line and know exactly how things were passed. And as a reminder, if you're in a mixed use community, so you've got residential and commercial strata lots, then you need 2 resolutions. So you'll need 2 3/4 vote resolutions, one passed by the residential units, one passed by the commercial units, in order to approve a bylaw for the community. And of course, nothing's enforceable unless it is registered in the Land Title Office. Years ago, the Strata Property Act used to hold our feet to the fire and put a deadline as to when we had to register our bylaws. They did away with that, and it was a benefit and a curse altogether. The curse of it is that there isn't this pressure to register right away, and some councils will forget. You've got a lot on your plate, and a bylaw that gets passed at a general meeting might not get registered at all. And so it's really, really important to stay on top of that in your community. Make sure you get them registered. When in doubt, look at the registrations in the Land Title Office to confirm that your little portable set that you carry around with you is actually reflective of what was registered as well. And wait, there's more, because I know everyone loves paperwork. So I'm going to add a little bit more to your plate. Stratas are responsible for keeping a record of their notice of general meetings and minutes of their general meetings as well. And when it comes to passing bylaws, there's some strict requirements. So your notice of your general meetings should include a full copy of the resolution and the bylaw for consideration. And then your minutes need to record the results of all your votes for these bylaw amendments or registrations. They need to be very clearly written. And why do we like that there? Well, it's a record for your community. So you can, if there's a challenge later as to whether a bylaw was properly reviewed or passed at the meeting, then you have this as a record to go back to. It will be an answer as to whether the right voting threshold was reached, whether or not there was a change that was substantive that we're not allowed to make to the bylaw or the resolution at the meeting without calling a new meeting and giving new notice. So really, really important that we stay on top of that record keeping. Okay. There is a time limit and a time consideration when it comes to passing pet bylaws. So as I mentioned, you are free as a community to pass a bylaw restricting pets or prohibiting pets. However, there is a situation called legacy pets. And what that means is if you're an existing pet in the property, then the new bylaw will not apply to that pet. And there's good reason for that. You might have lived with Fluffy in your strata lot for the last 10 years, and now your community is a dog community. They don't want cats, and Fluffy is on the #1 hit list. The law protects Fluffy. So as long as Fluffy is living with the owner, tenant, or occupant at the time the bylaw is passed, Fluffy is free to continue living there. Now, there are other bylaws that we'll talk about that regulate Fluffy's activity at the property. Hopefully she's not too noisy, but she's allowed to keep living there. And so your existing pets are under a legacy permission or exemption under the Act. Now, it doesn't apply to new pets. So just because Fluffy was allowed to keep living there doesn't mean that the owner can get a new cat to replace Fluffy when she expires. So very, very important to keep in mind that while the existing pets are protected, any new pets would be subject to the new pet bylaw.
Lisa, I was going to say one of the questions we had relates to how do you determine what pets are in the building? And I think this is a principal error that a lot of strata councils make,
Yes.
is that when they're going to change pet bylaws or adopt a new pet bylaw, the very first thing you need is an inventory of all the existing pets. Otherwise, you have no evidence of which pets were or were not in the building at the time.
Absolutely. And that's just adding to your paperwork. And I love it. I love paper. So those pet registries are a really good idea. So that's an excellent tip. Make sure that you know who the four-legged friends or two-legged friends or winged friends are in the building at the time the bylaw is passed. And that can be done with surveys circulated to the owners to complete a registration. I've seen people get very, very creative. They'll have a photo of the dog or the cat or the animal, but it's something that is part of the strata's record keeping. And it's really important later when there is an allegation that somebody has a pet in contravention of the bylaws. The strata can go back, look at their pet registration and see whether or not the animal was actually registered. Okay, so there are exceptions to every rule, and there is no exception when it comes to pet restrictions or prohibitions. So the Strata Property Act is very clear that all of our pet bylaws that govern or restrict pets or their access to the common property, for example, they don't apply to guide dogs or service dogs. So any provision of your bylaw that seeks to regulate those animals are not enforceable. And the Strata Property Act specifically acknowledges that the Guide Dog and Service Dog Act has a special meaning under this legislation and that these animals are exempt. So who are these animals? So they have specific definitions under that law. So we have guide dogs, and those are trained dogs. They're guides for a blind person, or they're certified as a guide dog. And then we have animals called service dogs. They're trained as well, but it isn't necessarily for a blind person. They could be trained to perform specific tasks to help somebody with a disability. And they're also certified as a service dog as well. So we see, for example, service dogs are registered for those that are hearing impaired, for people that have epilepsy, for example. I've seen a service dog who was certified and trained to assist with a child with autism. So there's a wide variety of circumstances and disabilities that might warrant the assistance of a service dog. And these are special animals. They're not actually considered pets. They're considered to be aids. So the Strata Property Act specifically exempts these dogs, these animals from the application of the pet bylaws. There is special paperwork and training that comes with these animals. So there has to be a public safety test that they take. There is specific training and limited accreditation schools that they're allowed to be trained at. There's a card that the carrier will have that authorizes them to take their dog into public areas. And there's a special certification process as well with that process. So very, very important that councils make sure that when they are looking to enforce their pet bylaws, that they pay special mind that that service dog or the guide dog just isn't applicable there.
There's an American company that basically advertises in Canada about how to register your service animal. And all it is you pay $50, you get a little vest and a card.
Right.
But unfortunately, pet owners are lulled into thinking this is a certification. But it does go to a really good question that I think everyone struggles with, is how much evidence and what credible evidence can people actually ask for?
Yeah, well, one of the first questions is you're allowed to see the certification card. You're allowed to ask for the proof of the training and certification. There's no privacy that's ascribed to that. Now, there is a bit of a limit. So when they have provided to you that certification card, the card for their handler to identify who's allowed to have the guide dog or service dog, and they should on the card indicate the medical condition briefly that authorizes the dog. There's a limit now. So once the council has received that proof of certification, then there is nothing more that the council can ask for from a privacy perspective. They're not allowed to look behind the legitimacy of the card or the certification. That's a different question for a different day. But when you do get that proof of certification, you get to view that card, then your job is done. Then as a council, you've satisfied yourself that this animal is under the GDSA protections.
So it's pretty obvious, though, that if the certification isn't issued by British Columbia or another provincial jurisdiction that you can identify, it's not credible.
That's right. And actually the government of BC on their website will list all of the legitimate training schools that are there. And so if there is doubt for your council as to whether or not you've been provided something that is fraudulent or that is not from an accredited school, then you can certainly reach out and ask and confirm. There are penalties under the GDSA in the event somebody misrepresents whether or not an animal is a guide dog or a certified service dog. So there are penalties there and available. But it is, Tony, it's something that I've seen with increasing frequency where people will reach out to companies in other jurisdictions, particularly America, and buy certification. And that may or may not apply when it comes to its application in Canada. I should say that the GDSA makes a special provision for certification in other provinces. So it used to be that you had to get certified in BC in order to register your dog, whether it was certified in Ontario before or another province, but now they recognize dogs from other provinces as well. So something to keep in mind. But yeah, if it looks too good to be true and too easy to get by a $50 fee, your spidey sense should be tingling there. Okay, so I want to draw your attention to Danford and the owner of Strata NW 3354. This was a case from the CRT in the last couple of years, and it was a good one. And the question of the day for that council was whether or not the dog in question was exempt from restrictions and access to common property when they weren't actually with their handler. So when they were off duty, so to speak. And the CRT went through a very in-depth analysis of the act. Now, the dog in question was named Gus. And of course, I always love looking at the dog names. Of course, nobody wants to get Gus in trouble. He can't read the bylaws, so it's up to the owners to know and understand them as well as the council. And in that case, Gus was, there was a debate as to whether or not Gus was going to be allowed access to areas of common property when Gus wasn't accompanied by their handler, when Gus was off duty. And the CRT noted that the Strata Property Act is very, very clear that Gus, as a registered service dog, was exempt from all bylaws that governed his or restricted his access to common property. And it was regardless of whether or not he was accompanied by the handler. The act is very, very broad in that regard. It exempts the pet, it exempts the animal, not who is accompanying the animal. So something to keep in mind as councils. I've seen a lot of debate on strata councils before where they say, well, what if the dog isn't working? Can this bylaw apply? I need proof that they're with the handler at all times. And this is the decision that we can look to, which is that's not the case. In this case, Gus was free to roam because the Strata Property Act is drafted in such a broad way. That case is also important as well because the CRT recognized the buck just doesn't stop at the Guide Dog and Service Dog Act. We have to look to the Human Rights Code as well. And that is another layer of considerations for council when it comes to whether or not a bylaw that prohibits or restricts pets is enforceable against a specific animal. So if you have a bylaw that prohibits pets, are you required to accommodate a person under the Human Rights Code, provided that they provide you with credible documentation or information? Spoiler alert, yes. And we will talk about a couple of other cases where that accommodation was warranted. Okay, so moving forward to the other discussion of the Human Rights Code. So the Human Rights Code doesn't specifically speak about pets. It speaks about the protection of persons with disabilities. And so there's a very, very broad net in terms of the animals that might be considered to be medically necessary for an owner, a tenant, or an occupant in your community, such that the pet bylaws won't apply to that animal. We might, as councils, have heard expressions like support animal, therapy animal, emotional support animal, or emotional support dog. If you've read the paper, you've probably seen some salacious arguments or articles about the need to allow for all measures of support animals. So there was, I think, on a Delta Airlines flight, there was somebody who wanted a therapy peacock with them, and there was a limit to whether the peacock would be able to board. But the code is very expansive. It doesn't specify a breed. It doesn't specify a type of animal at all that might be medically necessary. The key here is there is a duty to accommodate somebody's disability if that disability requires the presence of an animal, whether it's a support animal or a therapy animal, emotional support animal, and the person can verify for council that they are medically required. Then there is an obligation on council to make sure that they accommodate to the point of something called undue hardship, which is a high hurdle. It's impossibility, serious risk, serious expense, which obviously wouldn't apply in a pet scenario. But the requirement of council to consider these other animals is there.
So the big question that I think a lot of people have is that, and there's 7 or 8 of them in the Q&A already relating to the same thing, is that a support or therapy animal, it goes back to the whole issue of what's credible documentation, right? And is it the same as a service animal? Not in definition, but the accommodation may still be similar.
Absolutely. And in fact, the Human Rights Code accommodation supersedes, is actually takes precedence over the Guide Dog and Service Dog Act. And the Guide Dog and Service Dog Act recognizes that the Human Rights Code actually prevails over their requirements as well. There is no specific certification paperwork. There's no specific training. It's not like a guide dog or a service dog. The question of the day, if this were to go before the Human Rights Tribunal, is there sufficient medical evidence that there is a medical need for the animal? And typically what I encourage councils to do is to have the occupant, tenant, owner who is requesting an exemption from the pet restriction bylaw to fill out essentially a questionnaire for their physician, their treating physician, to fill out, to give you information, sufficient information to assess whether or not there is a medical need. So in the doctor's opinion, is the dog or cat or parrot, medically necessary to treat a condition. Is this a long-term or chronic condition? Because keeping in mind the Human Rights Code recognizes that disabilities have to be long-term. They're not temporary conditions as well. Are there alternatives that might be available in terms of forms of treatment? So somebody might ask for an exemption for their large dog, and the strata might have an existing bylaw that allows for tiny dogs. So is there some flexibility there? Why this dog in particular? So it's a great question. And the idea is the council needs to be reasonably satisfied that they've got enough information they need from a medical perspective to be able to approve the animal. We'll talk a little bit about the Personal Information Protection Act when it comes to an individual's right to privacy over medical information. But one of the key messages from the Human Rights Tribunal is it is an information sharing process. So when somebody wants an exemption to a bylaw, there is an expectation that they share as much information as council needs and reasonably requires to assess whether or not there should be a pet exemption in that case.
What about pets that are in training? So we have guide dogs in training, and they're accommodated in public facilities and restaurants. What about their occupancy is also short term? So,
Yes.
So what about the accommodation for a guide dog in training? Because it isn't really a certified pet, and it's not, and it isn't an accommodated pet under the Human Rights Code.
Yeah, that's right. And so in terms of the training and the license or the requirement to accommodate animals in training, the GDSA actually includes provisions. So they allow animals in training, guide dogs or service dogs in training are given special permissions as well, in addition to retired dogs. And service dogs, they're allowed to continue to live with an owner, even if they're replaced. So in retirement, they get special permissions as well. Now, you might not have something under the Human Rights Code because the Human Rights Code only gets triggered if the individual that requires the animal has a medical need. It doesn't apply that you are training up animals for others. It has to be a specific need to the individual. But certainly the GDSA includes special exemptions when it comes to both dogs in training as well as retired dogs. Okay, so two more cases I want to throw your way. So they were both from the Human Rights Tribunal, and they're again really good illustrations as to how far the code will bend to accommodate persons with disabilities that require an animal. So in the first one, daughter by parent, and the owner's strata, you'll see right away, well, who is daughter by parent and who's the owner's strata? So on the rare occasion, the tribunal will anonymize the parties. So in this case, the daughter was 14 years old. And so there was a request made to anonymize the parties so that they could protect her privacy, and that was granted. That's why the title of that case looks a bit different. She was 14 years old. She was diagnosed with diabetes. She had various mental disabilities. She struggled, there was evidence anyway that she struggled with depression, that she, it all originated from a childhood trauma. During the course of her medical treatment and things were getting very, very unsafe for her, she had suicidal ideations. Her parents received a medical recommendation to try a dog for her. And so the dog wasn't a service dog. The dog was just somebody that was, or an animal that was prescribed, if you want to use that term, to assist with her medical treatment. And there was evidence that the dog actually assisted her and that her medical conditions improved. Now, the Strata Council received complaints because the dog was in excess of the dogs that were allowed in the community. So the Strata did the first thing, which is usually the good first step in those communities that have a ban or an outright prohibition on animals, was to go to the owners at a general meeting and vote to pass a bylaw that enabled this individual to have at least one dog. And there was another bylaw that was entertained to say that council should have the ability to exempt dogs that are medically required. Now, that was an interesting bylaw because that law exists anyway, regardless of whether or not a bylaw was passed. But you can see that this Strata Corporation was trying to do what it could do to accommodate this individual and thought, well, we need a bylaw in place. Unfortunately, the bylaw failed. So it went to the vote. We don't have the details of how much it failed by, but it failed. The council was not successful in passing either bylaw. And so as a result, the mother of the child ended up filing a human rights complaint and said to the Strata Corporation, my daughter, you have medical evidence that my daughter requires this dog to live with her. We can't do so because of the existing bylaws and the prohibition on animals. And so we're making a complaint that you have not accommodated us to the point of undue hardship. Now, what's interesting in this is the case notes and the tribunal notes that the Strata actually didn't participate in this hearing. The Strata essentially deferred to the tribunal, noting that they acknowledge that any bylaw that contravenes the Human Rights Code would not be enforceable. And my sense is it's because the council of the day appreciated that the vote down of this reasonable bylaw would not pass muster at the tribunal level, and they wanted to work with the complainant. So the council, in their great wisdom and in good faith, decided to take a back seat to this complaint and simply told the tribunal that they would adhere to whatever decision or order was provided. That helped the Strata at the end of the day. The tribunal commended the Strata for their attempt to work with the complainants. They reiterated that yes, the bylaw was a contravention of the code because this individual who had an established medical need would be in breach of the bylaw, and so there was an exemption that was warranted here. And interestingly enough, because there was no resistance on the part of the Strata, no defense to the complaint, there wasn't any injury to dignity award that appears there. There was essentially recognition by the tribunal that the council should be commended on their behavior when it came to this complaint. So something that's really special in the Human Rights Tribunal. You don't often see uncontested complaints in decisions or frankly compliments that are given from the tribunal member to the responding party if they find that there's been a breach of Human Rights Code requirement. So something to keep in mind there. That case is also really good because it reiterates that this might not have been a service dog. This wasn't a service dog or a guide dog, but the medical need and the evidence of the medical need is enough. And so councils need to be educated that there is no specific certification, there is no specific training. If there's an established medical need, then there is a duty to accommodate as well. Jones is another one that council should keep in mind. This one was an individual who had diabetes and developed blindness as a result of that. Now, this individual was looking at moving into a one-level home and wanted an adult only community to move into. Recognizing their medical limitations. And so they picked out a townhouse complex that actually had, again, a pet restriction. And in this case, it was on weight. So there were only certain dogs that were allowed in the community. And if you were overweight, over a specific weight, then you were not allowed in. Now, Jones had a dog named Chloe. And Chloe, again, was not a registered or certified guide dog or service dog. Chloe did have an established medical treatment of the individual. So she helped alert Jones to hazards in the area when he fainted, when he was off on a bicycle ride, when he was off on a walk. She alerted a passing cyclist to his medical situation. And so there was clear evidence before the tribunal and evidence before the council in that case that Chloe did serve as part of the medical treatment for this individual. Now, they had intended to purchase their property. All of the paperwork was in, everything was going to be approved subject to all the conditions being satisfied. But the council said that you would need to apply to have Chloe approved. And they were under the understanding as well that there needed to be specific certification for Chloe as well. As a result, he was dissuaded from proceeding with the sale and purchasing that property. And the tribunal awarded him for his trouble. So the tribunal, in this case, it boiled down to credibility. There was a lot of he said, she said in terms of what transpired in advance of the sale collapsing. and ultimately recognized that Jones had experienced an injury to dignity and self-respect because of being denied essentially the ability to purchase and occupy a home because of Chloe, because of the presence of Chloe. And Jones was awarded $12,000 in injury to dignity. That's a significant price tag, but as a warning to everybody, the awards that are coming from the tribunal now are getting higher and higher each year. And I think the idea there is it's meant to be a deterrent to others for doing the same sort of behavior. It's meant to educate the public as to the importance of respecting everyone and treating everyone equal in dignity. And there are consequences to not accommodating those to the point of undue hardship. So it serves as a useful reminder to councils to know their obligations under the Human Rights Code. And note that unlike the previous case that I just mentioned, where the council was cooperative and deferential, in fact, to the tribunal and did not get an injury to dignity award against them, in Jones, it was not the case. It was a very much defended complaint.
So Lisa, one of the kind of the genesis of this problem, and we see it in a number of stratas, and one of the participants has raised this as a really great question, is strata councils, for consistency and to try and get the right information, create sample questionnaires that they give to the applicants to take to their doctor or service provider or whoever. But the problem with the questionnaires is you're almost prejudicing an owner's rights before they've even submitted the evidence, because there may be evidence information that's not part of that questionnaire that's critical in determining whether it's a credible accommodation or not.
Absolutely. And even when we're making a request for a physician to provide their opinion to a council, they get reviewed to make sure that each question you're asking is reasonably necessary in the circumstances. As you say, Tony, that template questionnaire might not cover everything that is relevant in the circumstances. And so in terms of councils who are doing this as a matter of course, circulating a questionnaire saying this has to be filled out in order for us to consider this, well, no, the tribunal is saying that you can ask for information. It doesn't have to be provided to you in a specific form. And I would encourage councils that are operating under this template to seek legal advice, make sure that their questions or whatever they're asking is actually reasonably necessary, and whether or not it fits in the specific circumstances. I find particularly with human rights, there is a tendency, and it makes life easier when we follow a formula, when we have a template, when we have a form, and we can get a little bit lazy where we say, here's the document you need to fill out, here's the agreement you need to fill out, but we don't actually have a specific appreciation for the specific circumstance. So yeah, very, very good caution there. And then I mentioned Personal Information Protection Act, PIPA for short, because the other full name is a bit of a mouthful. As you can imagine, when we are dealing with guide dog, service dog requests, when we're dealing with particularly therapy dogs, emotional support animals, requests for pet exemptions, you as a council will be receiving medical information. That is considered to be one of the most sensitive personal information belonging to an individual. Same with the certification documents as well. You're going to be getting a lot of details from somebody and specific to their person as to why they are entitled to an exemption. So council, it's really, really important that you keep this information confidential. This isn't something that gets broadcast in the minutes. This isn't something that gets passed around to owners. It is something that is sensitive. It involves a request that should be treated very similar to a hardship request. You'll notice under your standard bylaws, there is essentially a prohibition from observers attending certain types of hearings, and one is a hardship hearing. And why is that? It's because you're dealing with sensitive information that shouldn't be available to prying eyes. So council, keep this information confidential to yourself. Make sure as well that you're only asking for something that's reasonably necessary for you to process the request as well. So I've seen councils go on fishing expeditions where they ask for more and more information, even though they've been provided with sufficient information to establish that yes, this person has a disability, and yes, they have a medical need. I'll share a story with you that it was a little bit shocking to me at the time, but there was a case that we assisted a council with where initially the council was asking for proof of disability for an individual in order to process a accommodation request, and the person was visibly had a mobility disability. So this person had a wheelchair, and yet council was insisted, I need proof of your disability. So asking for things when it is not reasonably necessary or when it's blatant that there is a medical need will ultimately get a council and the strata in hot water. So make sure that you operate these requests with respect for people's privacy. Your privacy policy for your community. So that's a document that will track what information you collect, how you hold it, who it's shared with, how it's destroyed. It should dictate this specific area. So managing pet bylaws in particular, so that would cover your pet registrations and your exemptions as well. So make sure if you haven't developed a privacy policy, get one, develop one. Or if your privacy policy doesn't cover things like pet requests, guide animal or service dog requests, or pet exemptions under the code, make sure that you include that language in your policy to allow for that. Okay, so as I mentioned before, we have legacy pets. So your community might enter into a new regime where cats are prohibited, but your existing cat that was residing in the strata lot at the time, the bylaw does not apply to them, so they don't need to worry about that. It does become enforceable for any new pets that occupy the property as well. And again, that tip. So how do we know who's living at the property at the time the bylaw is passed? Get a registry. Circulate a questionnaire before you adopt or amend the pet bylaw so that you know what are the pets in the building and you have a proper record of that. And remember, it's all well and good that you've drafted your perfect resolution, you've drafted your perfect bylaw, but it's not going to be enforceable unless you file it with the Land Title Office. So make sure that you've gone through all of these hurdles to get your bylaws developed. Make sure that you take that last step to register that resolution and the bylaw amendment.
One of the early questions we had relates specifically to the filing of the bylaws and land titles, and the strata had not filed the bylaw in over a year. And the new buyer came in and the unfiled bylaw was not disclosed on the Form B. So the new owner comes in, of course, totally unaware of the bylaw, comes in with a pet, and then the strata attempts to enforce the bylaw, which they now have a serious problem with because they've not filed it and they've not disclosed it on the Form B. And I'm with you. The 60-day requirement, I think, was reasonable. Bylaws should be filed within 7 days. Otherwise, you forget them and they don't get filed. And if the bylaw isn't filed, it's not disclosed to anyone, it really becomes questionable as to whether it's enforceable at that point.
I agree. And particularly when it comes to purchasers, they're relying on that Form B. They're relying on what is registered in the Land Title Office. And they might choose a different property in the event that they knew that this property had a specific pet restriction or prohibition. So it's a very, very scary territory when we encounter communities that forget to register their bylaws. It should be a part of habit. So as you as a council, as soon as the bylaw gets passed at the general meeting, if you're self-managed, you need to get on it. And as I agree with you, Tony, that 7 days, yeah, you do make sure that you get on that registration, because I won't remember what happened 2 weeks ago, a month ago, and in this case, a year ago. The other tip that I have for any new councils coming on deck is it is really convenient to have for councils to have an amalgamated unregistered set of bylaws with them. So there might be a series of bylaw amendments over the years. And so they have this sort of cheat sheet consolidation of everything. Be very, very careful of those cheat sheets, because we want to make sure whatever consolidated copy we have, that all of the bylaws in that copy are in fact registered. So when in doubt, look at the Land Title Office and see actually what's registered for your community as well. Now, there is a special limitation in place for phase developments as well. So when there is a development that's being constructed in phases and the owner developer is on track in terms of making the next phases, then you need the owner developer's consent in order to pass a pet restriction or a pet prohibition and file different provisions in the Land Title Office. So essentially, unless you get their consent or you're after the final phase and the annual general meeting, the first annual general meeting has been held, you do need that other consent available. And there's good reason for that too, because the developer will have certain marketing for the property. It'll impact the new phases as well. So just keeping that in mind there too. And so who do we have on the screen right now, Tony?
We have Mr. Jethro. He's mine. It's my building. I thought it would be a good example on the extreme case, right?
Yes, I love. So I think what Jethro is illustrating is that that's his couch.
It's his apartment too.
So so 175 pounds, that is huge.
Yeah.
Just a baby, 3 years old, one of 35 dogs and 22 cats in a 250 unit high rise. The bylaws and the rules are, as a matter of course, in this community are distributed annually as part of the AGM. Great way of educating the owners as to what the bylaws and the rules are, of course. And Jethro has not had any pet violations or complaints. None of the other animals in the building have either for the last 7 years. So the question of the day is, does size matter? We do see a trend in communities that are very specific on their bylaws for regulating weight, for regulating breed, type, and that's not necessarily an indicator of whether or not there's going to be a pet problem. This is a great example of the fact that we can have animals of all shapes and sizes and no disruptions at all in the community.
Well, and I think that owner and tenant education on a routine basis is the key to making this successful, and facilitating this. You know, as well, we also have a pet washing station on our second parking level. So people coming in from outside when it's rainy, muddy, snowy, salty, whatever it is, there's a location that they can go and wash their pets down before they come through the building. So it really reduces wear and tear on carpets and surfaces in the building as well. And you know, there are pet stations throughout the building if an animal has an accident, and everybody's aware of what the protocol is. So I think if you're going to allow pets, allow them and manage them in a way that they're a good, vital part of your community and everybody is aware of what they are. We also have a pet registry in our building, which we don't do for the sake of enforcing the bylaws. We do it for the sake of emergency services in the event that there's a fire or something, being aware of where all the pets are if pets need to be rescued as well as people.
That's a great consideration. Actually, I recommend for residential landlords when they are renting a property and the tenant has a pet, that there is an emergency contact specific for the pet as well. So in the event something happens to the owner, the pet owner, there's a pet caregiver that can be contacted in the event of an emergency. It helps them understand exactly who's in the property in the event that the owners are not home and the property needs to be vacated. It's a great idea. I do also love the recognition that they are parts of your community. And there are ways that we can navigate the existence or presence of pets that don't necessarily mean restricting the size of the pet, the weight of the pet. Keep in mind that pet behavior is also regulated under the use of property bylaws. So we tend to forget as a council that we have a lot of different tools at our disposal to regulate bad behavior, whether that comes from a person or whether that comes from their pet. And usually it's combined. So you rarely have a bad pet without a bad pet owner, frankly. And so we do have these use bylaws that prevent owners, tenants, occupants from using their strata lot in a way that causes a nuisance, that creates unreasonable noise, in a way that's unreasonably interferes with others. So we have these other protections there that could equally apply to somebody's pet management or their pet behavior. So keep that in mind, that that's a useful tool in your tool belt.
So one of the questions that comes up is and I think it's our next slide, are weight or size bylaws enforceable? And we have seen them enforced across the country when it comes to size and limitation on size. But I think the application of the bylaw has to be reasonable. So if you have a bylaw that says no pets over 15 kilos, and and all the pets in the building have been under 15 kilos, but one of the pets is suddenly on a bit of a ravenous diet, and now is 16 or 17 kilos. Does
Yeah.
that become a pet in violation? Like what's a reasonable enforcement on that level?
Yeah, and it is, and I do encourage councils when they are passing these bylaws. I feel like there is unreasonable reliance that when you craft a bylaw that limits the weight or the size of an animal, that you are protecting or guaranteeing that there will not be any pet related nuisance in your community, and that is not a guarantee. I can speak personally. I have two little dogs that live next door to me, and they are louder than the larger dogs that live in our community as well. And they would, so if our community actually regulated the size or the weight of dogs and presumed that smaller dogs were less of a nuisance than larger dogs or less disruptive, I could guarantee that is not always the case. I think what's important when communities craft bylaws, whether it's a pet bylaw or any bylaw, or what are your community's unique needs? What are your goals? Do these bylaws actually meet your goals? What is the objective here? Is it to curtail noise? Is it to limit access or wear and tear? And Tony, you raised a really good tip in terms of the common property use in your community, that there is a pet washing station. So how do we manage the common property and access in a way that makes sure that we don't have these accidents, or we don't have disruption that might result from pets traveling across the common property? Do we have any safety concerns? Is it a capacity issue? There's a lot of consideration that goes into managing pets. And of course, you can have bylaws, and we've certainly assisted with communities that are quite insistent that they want shoulder height bylaws, for example, for dogs, that they want to ban specific breeds of dogs as well. But it's really important that as a council, as a community, you dictate how or consider how you want to be regulated. Keep in mind too, purchasers see that material as well. So it's an advertisement for your community in terms of how you engage with others.
Yeah,
okay.
so I was going to say aggressive, vicious, or
Yeah.
Troublesome pets. I think this is a real concern for a lot of communities.
Yeah, and it's interesting. So I was helping one strata out once that really wanted to put an outright ban on certain breeds of animals. And one of them that was included was a German Shepherd. I actually had a German Shepherd growing up, and I could say that when I was a 3-year-old, put buckets on its head and it was completely docile, and there wasn't any issues there. What I do encourage people to do is, instead of having the breed specific bylaws, which might not actually target the behavior that you're looking to target, if you do want to have an aggressive or vicious dog, you might want to look at the animal control bylaws in your municipality to flavor the restrictions that you have. And the animal control bylaws are an interesting read. In your municipality, the city of Vancouver has one, and it's quite interesting in terms of the details of animals and restrictions that are in place there. Literally bans lions and tigers and bears. Oh my. So keep in mind as well that the municipal bylaws still apply to your community. So that's another layer of protection as well. So if your municipality bans a certain breed of animal or bird or reptile, then there is that added layer of protection there. I always get a little bit worried when we're specifying breeds or specifying types of animals, and then we miss one and we say, oh, well, now I want to add this because I forgot this breed, or now there's a new breed of animal and I want to amend to add this. I actually like targeting behavior as opposed to the specific breed. I don't know about you, Tony, but I feel like there is a trend to target breeds, but I'm not convinced that necessarily manages the behavior.
Well, we hear the line frequently that there are no bad dogs, just bad dog owners.
Yes.
And there's certainly some credibility to that, but there are some breeds that are prone to more aggressive behavior than others. And I think, like you, I say, let's parallel the municipal bylaws.
Yeah.
Our local bylaws may do it, but an interesting local bylaw that we don't have on the slide here, but I came across it yesterday, that permits domestic chickens within backyard areas if the backyard meets a certain size and containment and whatnot. And within that municipality in BC, there are a number of townhouse complexes that actually qualify.
Okay.
And so, the Strata really needed to think, do we want to permit chickens in the backyard areas?
Yeah.
Because it raises a whole other level of concern for the residents.
Well, I hope you're a morning person if you have chickens around, because they can be one of the most rowdiest guests in a community. So I also, on a personal level, find chickens terrifying. If you've ever been in the chicken coop before to retrieve chicken eggs, it's not a pleasant experience, let me tell you. But yeah, I think paralleling with the municipal bylaws is a good thing. So have a stroll through your the animal control bylaw. I can see I just pulled up the City of Vancouver one. So they actually go into quite a lot of detail in terms of what they prohibit. But alligators, crocodiles, bears, hyenas, wolves, foxes, anaconda. There's a wide range of animals that are prohibited here.
It's a good tip for everyone, though, to look at their local government bylaws.
Absolutely. And there could be special needs in your community as well. So we assisted a Strata once who had a daycare operation in the building, and they were concerned with respect to larger dogs or vicious breeds of dogs. And it made sense as to why they didn't want to impose that possible risk in the community. The same with a community that I was assisting with. It was a rental property, but they had a lot of older adults in the building, and they were concerned that large dogs might knock over older adults. And so their technique, their strategy was to ban a certain weight of dog. Now, there could have been an alternative in terms of requiring leashes at all times on common property, properly restrained and controlled at all times. But it is a consideration that each community should have. And again, if we can reiterate anything when it comes to bylaws, there is no cookie cutter way to proceed. You have to go by what is best for your community, and only you as council will know that, and only you as the owners will know that as well. Typically, what we see regulated are the domestic pets that we see most commonly. So dogs, cats. I've got reasonable number of fish there. That is the language straight out of the standard bylaws to the Strata Property Act. Typically, for the fish bylaws or any aquarium tank, any liquid filled item, there is a recommendation to limit the size of the tank. And why is that? Because when water escapes, it just goes down. So there might be a reason to avoid a potential claim for property damage if you don't limit the size of aquarium that are in these, particularly in the apartment style strata lots. There was one owner that had installed a huge aquarium, saltwater aquarium, and there was no limit on the aquariums at the time. And I know that that was a significant concern from council in the event that there was a leak. If the owner wasn't there on vacation, there was a real concern that if the tank burst, it would be a huge liability risk to those beside and below, frankly. The standard bylaws also include some tips with respect to regulating small caged mammals and caged birds. By default, you'll get the reasonable number of small caged mammals, reasonable number of caged birds. And again, what is reasonable? It's up for debate. I mean, I've certainly seen decisions where in the rental context, when 5 dogs in a bachelor apartment was considered to be reasonable. I don't know who would share what space with 5 other dogs, depending on their size, but you have to exercise your reasonable discretion there as well.
And the municipality actually contains limits on pet numbers as anyhow.
Yeah.
Three dogs, for example, is the limit City of Vancouver. And so, each municipality has different limits, but, we had I was looking back in 2003, we had a dog that was home alone. So it spells recipe for disaster right off.
Yes.
And knocked over a 50-gallon fish tank on a stand,
Oh, gosh.
which did an enormous amount of damage to that unit and 4 of the units below. 50 gallons is a lot of water.
Yeah.
And so, size of tanks, the capacity of the tanks, a number of stratas are even limiting down to 10 liters.
Yeah.
That's only 2.5 gallons, basically, but that's still a substantial amount of water to cause damage.
Yeah. everybody into the pool, so to speak. That's
Everybody into the pool.
Exactly.
Just on your point about pets on a leash,
Yeah.
one of the questions that's come up is an owner who has a physical disability can't manage their dog safely on the leash. They're afraid of being pulled over or pulled down the stairs. But the Strata has a bylaw that says all pets must be on leash and under control. So how does the Strata cope with that kind of accommodation?
It's the same consideration. So can I accommodate this individual's request to the point of undue hardship? So I guess the first question is there actually a risk that's presentable with this request? And the individual has clearly explained why they aren't able to meet that bylaw requirement. And so unless council can demonstrate that it's impossible or a serious risk to accommodate that request, if the animal is controlled otherwise, is well behaved, is not running around, then a council would be very, very hard pressed to establish that bylaw is still enforceable against the individual. There needs to be some consideration and evaluation as to this individual's medical needs. If they've established a medical need and a concern that they have to control the animal in a different way than your bylaws contemplate, then that is a question that council needs to decide. There is inherent flexibility when it comes to the Human Rights Code. I call it the yeah, but law. Yeah, your laws might say this, but the Human Rights Code goes one step further and says, do I have to apply it in this circumstance? And the question of do I need to apply it in this circumstance is a good one when we talk about tenants as well. So tenants in rental properties, they can spark a lot of debate on councils in terms of how do we regulate tenant behavior, or in this case, how do we regulate pets in rental properties? The first question was a common question I get asked is, can a strata impose different conditions for tenants in relationship to their pets? The answer is no. So tenants are people too. We're regulating pets. We shouldn't really regulate anything that might be interpreted as imposing a term in a tenancy agreement. So the Strata Property Act specifically prohibits councils from meddling into tenant screening, from meddling into inserting requirements into tenancy agreements. So you want to be very, very careful that your pet restrictions or prohibitions apply to the community at large and don't specifically target a rental relationship. There might be a challenge there as to whether that's enforceable. Is a landlord allowed to make more restrictive pet conditions for their tenants than is otherwise permitted under the bylaws? Yes. So your community might allow for one dog or one cat in a strata lot, but the homeowner might not want any animals in their strata lot. And so, yes, it's open to a landlord to restrict or prohibit pets that are otherwise permitted in the strata. Same considerations apply to landlords as stratas. If somebody establishes a medical need for an animal, then the same considerations apply. That term of a tenancy agreement may not be enforceable in the circumstances. Do bylaws apply to the tenant's visitors or visitors generally to the property? Yes. And so, and again, check your bylaws to make sure how they're drafted as well. So see how you'll see in the standard bylaws appended to the Strata Property Act that we say owners, tenants, occupants, visitors. And so make sure that your bylaws are drafted in a way that capture the conduct of everybody. And same goes with your rental agreement language as well. What about therapy pets for visiting clinical services? Well, if the visiting clinical service is there to assist somebody with a medical condition, then yes, there are going to be a duty to accommodate that medical treatment as well. So again, look at your bylaws to see how specific they are in the circumstance, whether or not it speaks to who the individual is that has the pet. But I would make an argument is if there is an occupant at the property that requires pet therapy, and that involves bringing a pet through the common property or taking them to their home, that pet prohibition that might be in place is going to need to flex to accommodate that medical treatment.
Wow, there we go. Lisa, that was pretty amazing. I've just got one or two more questions, but we're also out of time. So I know people want to go. So just a few more questions to kind of deal with this. So one of the very earliest questions, which I think is a great question because it's often misunderstood, is the strata is creating or forming a committee to enforce and police their bylaws.
Yes.
And this has a number of conflicts with the Act and the standard bylaws, but notwithstanding some really serious liability risks.
I agree. So anytime I hear the word committee, I get my spidey sense up, so to speak. So committees are it's a trend. It's one to help delegate, or it's supposed to help delegate or share in the work that councils are doing. And councils are made up of volunteers, and that's a lot of time and effort to be on a council. But councils are not allowed under the Strata Property Act to delegate things like bylaw enforcement onto a non-council member. You as council members, unfortunately, the buck stops with you. You have a duty under the law to be able to enforce the bylaws and to regulate the common property and do everything else that the councils are required to do under the Act. From an insurance defense perspective, so sometimes we make mistakes as council members and we might be sued for it. And the Strata can obtain insurance coverage that will defend you if you've been acting in good faith and in your role as a council member. But that coverage, by and large, will probably not extend to a committee member who is not actually authorized representative of Strata, meaning they're not on council. So I get very, very nervous when I hear that people are delegating these important tasks to committees, and those committees are not made up of council members. That's a huge concern for me.
Yeah, notwithstanding any of that, they're just not going to have any success at CRT trying to enforce their bylaws when it comes around to it.
No, and the CRT, I do recommend that people have a look at the decisions they publish from time to time. You'll see a common theme there. And one of them is to make sure that councils are accountable and that they know and exercise their rights and obligations under the Act and enforce the bylaws. So if it becomes an issue for the CRT that somebody has delegated a task to a committee like bylaw enforcement, then that's not a decision that you want your name attached to, because it will end in a very poor way.
Okay, one more on accommodation.
Yes.
Because I think this is what really, that Strata councils really struggle with this more than anything. But generally, a letter from a doctor is provided that the person's cat, or they need to get a pet, a cat or a dog, which is a comfort pet or a comfort cat or dog. Mm-hmm. Is this a reasonable test for accommodation?
The purpose is that it's a comfort animal?
Yes.
Well, I guess is there a medical need there? So
Right.
What is the purpose of the comfort? So is it to treat a medical condition or a medical disability? So as I mentioned before, I've seen therapy animals be prescribed to treat autism, depression. And the idea is that it's comforting or for anxiety conditions as well. The answer is it depends. And so anytime I see a request that's for a comfort animal, or we use words like therapy animal or emotional support, there's further investigation that's needed. So what is the medical need associated with that animal, not necessarily the label that we put on that animal.
So this is really where it comes to gathering more information, and oftentimes a response either from the Strata Council property manager or even the lawyer for the Strata to the person who's provided this recommendation, for them to provide some evidence or diagnosis that there is a medical requirement here.
Absolutely. And the tribunal recognizes that, listen, when we're talking about accommodation, they're recognizing that Stratas, you do have an obligation to enforce your bylaws. And that's a big obligation. So there will be an information sharing and cooperation as between the person who's asking for an exemption and the council who is making a decision on the exemption as well. And so for owners out there or tenants or occupants that are wanting an exemption, be mindful that the tribunal requires you to cooperate and share. And some of this information is going to be sensitive, but your council has an obligation to keep that sensitive information protected as well.
Lisa, Thank you so much. This is wonderful. This will make a great session to be posted onto the website. And many of the questions that are still up there, we've actually addressed them earlier on in the session. I think some people came in later, so we invite you to go back and view the entire session once more. It'll be posted later this afternoon to the website anyhow. If you have any additional questions, I know that Lisa would be happy to receive your email. Send us an email at the office. We'll find you some resources. Next week's session, if you're interested, is next week's webinar is winding up a strata corporation, as we have more and more pressure for older strata corporations with large properties now being pressured to consider winding up and selling their properties for redevelopment. So join us for next week's session as well. And thank you very much for joining us all today. And again, Lisa, thank you so much.
Thank you for having me.